judgment in the matter of a reference by the Attorney General for Northern Ireland and the devolution issue under paragraph 34 of Schedule 10 to the Northern Ireland Act 1998.
This case concerns individuals who are adults and who, for reasons to do with impairments in mental capacity, are looked after in care environments of various kinds. They may be kept there in circumstances of confinement for their own care and safety and that of others. In terms of domestic law, this does not qualify as false imprisonment. However, the legal question which arises on this reference is whether they suffer a deprivation of liberty under Article 5 of the European Convention on Human Rights. Article 5(1) provides that everyone has the right to liberty and security of person, and that no one shall be deprived of his liberty, save in specified circumstances and in accordance with a procedure prescribed by law. Where there is a deprivation of liberty, Article 5(4) imposes certain procedural requirements to allow the deprivation to be challenged in court. The individuals the court is concerned with do not have mental capacity as a matter of domestic law to make their own decision about their residence and care arrangements. So under ordinary domestic law, they cannot validly give their own consent to those arrangements. But it does not follow that they are being deprived of their liberty for the purposes of Article 5 of the Convention. The law under Article 5 depends upon concepts of European law which are autonomous in the sense that they have a life of their own and a meaning different from domestic law. Under Article 5, a distinction is drawn between deprivation of liberty, which such as happens when someone is detained in a prison cell, and mere restrictions on liberty of movement, as happens in a range of social situations where that provision does not apply. The case law of the European Court on Human Rights in Strasbourg also employs another autonomous concept, namely that an adult with mental impairments can still validly consent to their confinement. If they do, no deprivation of liberty occurs within the meaning of Article 5. That is so even though they do not have full mental capacity as a matter of domestic law. One of the questions which arises on this appeal is what counts as valid consent for these purposes. The present case is brought to the Supreme Court by a reference made by the Attorney General for Northern Ireland to test whether the relevant minister in Northern Ireland would be acting within their legal competence under the Northern Ireland Act 1998 in issuing a new code of practice to give guidance to health and care professionals about the care and treatment of adults with impaired mental capacity. According to the 1998 Act, the minister will only act within competence if he complies with the rights set out in the Convention. So the new code of practice should not give guidance which will lead relevant professionals to treat individuals in care in a manner which is not compatible with Article 5. The new code of practice the minister wishes to promulgate adopts a comparatively narrow view of the meaning of deprivation of liberty under Article 5 and a comparatively wide view of what qualifies as valid consent in European law to care arrangements involving an element of confinement. The effect of this is to narrow down the range of individuals in care settings to whom Article 5 will be taken to apply. The minister says that this is correct as a matter of law. He also says that it is a desirable position in policy terms because persons in care benefit from a range of other protections under the Convention and in domestic law, which are better suited to their situation. Those protections involve less intrusive measures of checking that they are being properly cared for than arise under Article 5, which would be beneficial in terms of safeguarding their own well-being and maintaining good relations with their carers. It would also avoid extensive misapplication of limited resources of psychiatrists and other care professionals in the care and health systems, which can otherwise occur if Article 5 is held to apply, due to the extensive additional checking obligations which are associated with it. The main reason a reference has been made is that this court gave a judgment in a case in 2014 known as Cheshire West, in which, by a majority, it held that the meaning of deprivation of liberty was comparatively wide and that the notion of valid consent was narrow. Indeed, if there was a lack of mental capacity in domestic law, it did not have a significant role to play. The question therefore arises whether this court should overrule that decision if the court is persuaded that the majority in that case misapplied European law. For that reason, this court sat as an enlarged panel of 7 justices. As I will explain, this court is unanimously of the view that the majority decision in Cheshire West interpreted the phrase deprivation of liberty in Article 5 too expansively and was in error. The court is satisfied that this has led to severe misallocation of resources in the care and health systems to carry out the additional checks this has required, and is also satisfied that it has created a situation in which the proper development of the law has been compromised. The court therefore holds that the majority decision in Cheshire West should be overruled. The court's reasoning regarding the meaning of deprivation of liberty and valid consent in this context may be summarised as follows. The Strasbourg Court has given extensive guidance about the meaning of these autonomous concepts. A deprivation of liberty for the purpose of Article 5 has both an objective and a subjective element. The objective element is satisfied where the person is confined to a particular restricted space for a material period of time. An important aspect of the subjective element is that it may be satisfied where there is no valid consent to that confinement given by an individual with awareness of the situation they are in. The majority decision in Cheshire West was to the effect that there is an acid test for a deprivation of liberty, namely simply whether an individual is subject to continuous supervision and control and not free to leave. The unanimous view of the court on this reference by the Attorney General is that this interpretation of Article 5 does not properly reflect the guidance given by the Strasbourg Court. This court reviews that guidance closely and in detail. There is not a simple acid test. Instead, it is necessary to consider a range of factors bearing on the question whether a particular situation involving limits on a person's liberty of movement constitutes a deprivation of liberty or only a restriction on liberty of movement. It is relevant that the purpose of confinement is the safekeeping of the individual rather than to punish them. It is also relevant that the circumstances in which confinement occurs are kept as close to normal living conditions as possible. These factors indicate that maintaining adults with impaired mental capacity in a care environment will often not constitute a deprivation of liberty, even if there is an element of confinement for their own safety. The individual's subjective appreciation of and reaction to their situation is also relevant. In marginal cases, it is also important to compare the situation with the paradigm case of detention in a prison cell to see how close or how remote the analogy is. Other than in fairly extreme cases of confinement, maintaining an adult in a care environment is remote from the paradigm case of detention in a prison cell, which again points away from such situations being a deprivation of liberty rather than a restriction on liberty of movement, which falls outside Article 5. This court also unanimously holds that the majority decision in Cheshire West fell into error by effectively discounting the role played in this area by the autonomous European concept of valid consent. An individual with impaired mental capacity, so far as domestic law is concerned, is nonetheless capable of giving valid consent to their living arrangements, according to the guidance given by the Strasbourg Court. The concept of valid consent is treated by the Strasbourg Court as part of the definition of a deprivation of liberty. If valid consent is given, there is no deprivation of liberty. The concept of valid consent in this context is concerned with a person's de facto understanding of their situation and how they experience it. A person may not have mental capacity, according to domestic law, to make decisions about their care and residence arrangements, but if they have a basic level of awareness and consciousness of their living arrangements, that is sufficient to enable them to know and communicate whether they are happy or unhappy with them. They may be treated as able to give or withhold valid consent to confinement by an expression of their wishes and feelings. It is right that weight should be given to their own views on such an issue, as a matter of treating them with the dignity and respect due to them as individuals, which is an important feature of the Convention. However, the Court emphasises that appropriate care has to be taken in making the assessment of whether they are consenting or not, and in cases of serious doubt, the inference should be that they do not consent. The result of this analysis is that the Court concludes that the new Code of Practice, which the Minister proposes to promulgate, is compatible with Article 5 as properly understood. It is therefore within competence for the Minister to proceed with it. This Court is now adjourned.